Hello everyone, welcome to another session of Lucid Mails. Today, let us look at the issues that surround the Forest Rights Act of 2006. Now, this topic is extremely important for your general studies paper, be it paper 1, 2 or 3. So, let us look at what the recent events are. In February this year, the Supreme Court in Wildlife First versus Ministry of Forest and Environment issued an order stating that all persons whose claims have been rejected under the Forest Rights Act need to be evicted. This order is supposed to affect over 10 lakh people in the country. Though the court directed that the eviction may be carried out by July 24th, it later stayed the order permitting states to temporarily withhold the eviction. So, let us take a detailed look at what the Forest Rights Act is. Back in the colonial era, the British diverted abundant forest wealth of our country to meet their economic needs. This resulted in immense distress for the forest-dwelling communities in India. After independence, the government initiated several measures to correct the historical injustice done to the tribal and forest-dwelling communities. This was first recognized in the form of the National Forest Policy of 1988. Later on, in 2006, the Forest Rights Act was created to provide a rights-based approach in dealing with the claims of forest dwellers. Officially called the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006, the Forest Rights Act or FRA legally grants forest rights to scheduled tribes and other traditional forest dwellers. This includes the responsibility for sustainable use of forest resources so as to strengthen forest conservation program. The Act also ensures the livelihood and food security of forest-dwelling communities. It entitles communities' claims over their generational land. The Act was highly significant in the light that for the first time it granted negotiating power to the tribal communities. Now, the present controversy is surrounding the eviction of people whose claims under the FRA were rejected. So, let us take a look at the recognition process. The Act recognizes individual rights of scheduled tribes over forest area if they can prove their occupation before 13th of December 2005, that is, the time just before the legislation of FRA came into force. On the other hand, the other traditional forest dwellers need to prove continuous existence in the forest for 75 years. For initiating claims, the Act mandates that every forest claim must be accompanied by 2 documents as evidences, which could be documents issued by government, research studies, statements by elders, and even physical evidence of possession or use of lands and amenities such as wells. The approval process is carried out in 3 stages, starting from the Gram Sabha. Here, we must note that no forest officer, wildlife or environmental NGO is part of this process. Neither is the Ministry of Environment and Forest. So, talking about the 3 stages, the first stage of scrutiny is done by the Gram Sabha. A Forest Rights Committee is formed under the Gram Sabha. They, along with the officials of the Revenue and Forest Departments, verify claims by making field visits. Then, the committee submits its opinion to the Gram Sabha, which approves or rejects the claim. In the next stage, the approved claims are forwarded to the sub-district level committee for review. If approved by the SDL committee, the claim is forwarded to the final level called the district level committee, which is headed by the district collector. It is the final legal authority to approve or reject claims under the Forest Rights Act. The appeal against rejections also follow a similar pattern, but there is no provision for appeal against the final order of the district level committee. Now, according to the latest report prepared by the Ministry of Tribal Affairs in November 2018, 46% of the claims under the Forest Rights Act has been rejected nationwide. Now, let us look at what this implicates. The first issue regarding mass eviction is that it violates the guarantees provided by fundamental rights. According to the 2014 report of Saksa Committee on Scheduled Tribes, about 60% of the forest area in the country is in tribal areas, which enjoys protection under Article 19(5) and Schedules 5 and 6 of the Constitution. Also, large share of Indian farmers are landless. They depend on the common lands or public lands and adjacent forest lands for the fuel, fodder, minor forest produce, etc. Forcing them out would render them without a decent source of livelihood. So, if forced eviction is carried out, it is bound to go against some of the basic constitutional guarantees that our citizens enjoy. The next issue is the large number of rejection of claims. It is quite surprising that 46% of the claims are rejected. What makes it ironic is that most of these rejections were made without assigning any particular reason or on flimsy grounds like absence of GPS survey or wrong interpretation of the definition of forest dwellers. Also, in certain states such as Jharkhand, decisions on forest right claims are often influenced by the local forest department, which goes against the ideas that were created in the Forest Right Act. Also, RTI responses in certain states have suggested that in many villages, forest rights committees were not formed to look into the claims. Now, because these rejections are not communicated to the claimants, it inhibits their right to appeal. The next concern is the general lack of awareness among the people. Being poor and illiterate, living in remote areas of the country, the forest dwellers generally do not know the appropriate procedures for filing claims. Also, the Gram Sabhas, which initiate the verification of these claims, are low on awareness of how to deal with them. Another issue that plagues the efficiency of the Act is the lack of evidences to support the claims. Documents as old as 75 years are hard to come by, even in India's urban areas. Thus, demanding dwellers to furnish satellite imagery and non-existent 75-year-old records as evidence has severe limitations. To add to this woe, some states often make additional demands that are not part of the law, like Gujarat in 2008, which insisted on records of the Forest Department as documentary evidence. Besides these, the biggest issue regarding the Act is its poor implementation. Confusions regarding the interpretations of various definitions in the Act continue to prevail. Also, the Act lacks a sunset clause. So, despite being in place since 2006, claims can be filed even today, which indirectly aids in legalizing encroachments into forest lands. Several states have also diluted the provisions of the Act, especially those which aims to bring back the Forest Department into the preeminence instead of the Gram Sabhas. The lack of third-party verifications further crippled the effectiveness of the Act. For many years, various NGOs have alleged that a large number of the forest lands was recognized simply due to external political pressure and through corruption. So, to conclude, despite being in existence for over a decade, the Forest Rights Act is largely a failure. Now, there are millions of tribe and other traditional forest dwellers in India who are considered encroachers on the land which they live simply because the Act has failed its purpose. So, it is now up to the government to revamp the Act so that it meets its objectives. This can start by initiating a third-party non-government agency verification to assess all the claims using GIS and remote sensing technology. This will ensure that the economically underprivileged parties are not affected adversely, along with enabling the courts to decide the cases on its own merit. Also, as a long-term strategy, the government needs to think about initiating land reforms 2.0. Experts have repeatedly opined that it is the failure of the earlier land reforms that has pushed the people to encroach into the forest lands. Now, with a sharply bulging population, this trend is expected to keep up, thus causing more threats to the forest as well as its dwellers. Now, when it comes to conservation, in most countries of Europe, forests are largely owned and managed by individuals and local communities. This not only helps in generating income for them, but also aids in conserving and using forest resources in a sustainable manner. Mexico, for instance, has handed over 70% of its forest to communities for management. India's Forest Rights Act is also a step in the same direction, but its poor implementation remains an issue. Thus, in order to face a climate uncertain future, India needs to rethink its attitude towards the forest and its people. Lastly, the failure of Forest Rights Act points to the country's inability in dealing with its landless population and poverty. It also asks the question whether such issues can be addressed by distributing what is left of India's fragile forested landscape. Thus, this issue needs to be seen as an eye-opener to the failure of inclusive development and as a pathway towards formulating new strategies and long-term policies.